I'm Eric Lanigan with Lanigan&Lanigan, attorneys in Winter Park, Florida. I'm going to talk for a few minutes about some fundamental principles of bankruptcy law, specifically as it relates to a Chapter 11 bankruptcy. Another thing that occurs in early on in a Chapter 11 bankruptcy is what we generically refer to as first day orders. And these are requests for orders that are submitted almost simultaneously with the filing of the bankruptcy, and generally they deal with just an order allowing certain day-to-day mundane things to continue, which in the normal course of business you wouldn't need an order to do it, but obviously now you're under the supervision of the bankruptcy court, so you need to get an order entered. For instance, an order to hire the debtor's attorney to represent the entity in the bankruptcy proceedings, and also as to any creditors' claims and creditors' issues. An order to pay the employees their regular wages. An order that sets forth the terms of the use of business revenues, which it may be very generic and essentially just says that the business revenues can be used as commonly used in the ordinary course of business. Buy inventory, make repairs, do things like that. But so you get a general order entered to that effect. So those are some of the basic things that go on very early on in a Chapter 11. To me, the most important things are that the debtor is allowed, under the concept of debtor in possession, to continue to operate the business. And as long as they do so in a honest and reasonable manner, they will continue to operate the business throughout the bankruptcy proceedings. And the other thing, of course, is the automatic freeze, which stops aggressive creditors from basically wrecking the business. We've had situations where in clothing stores where we had a creditor who was literally within days of backing up a truck and seizing and hauling away all of the inventory. Well, the business would be instantly over. And not only would they not have anything to sell, but everybody on the street would see this going on, and obviously that's the end of business. So that, I think, is one of the most important things. But another very important principle is don't wait too long. And we had this very recently in a case where it's an individual Chapter 11. The person owns multiple properties spread out over several different states, as far north as New Hampshire and into Florida. They became embroiled in incredibly complicated litigation up north, and the judge was really, let's put it kindly, was ruling against them on virtually everything. And a layman might use terms like getting railroaded and things like that. The problem we had is that so many of these issues had already been brought before this state court and ruled upon by the state court up north. And one of the first things we heard when we went into bankruptcy court was the bankruptcy judge looking at me and saying, "Mr. Lanigan, we are not going to relitigate any of these issues that have been tried up in Massachusetts. So whatever's happened there, you're stuck with it." So that really put us in a straitjacket that almost doomed the Chapter 11. And so you hate to say it to a client, but the bottom line was, if you'd only been here a year ago, when all of this litigation started going bad, and realized that it had to get cut off and get this into a different court, none of that would have happened. But because it was too late, we're stuck in a straitjacket, and basically the case was almost completely doomed from the beginning. So don't wait. If the business is going south, get into a lawyer's office who knows something about Chapter 11. Discuss your situation. Determine whether or not it's time to file. Or if not, what can be done to avoid or to deal with the creditor, and possibly even to avoid filing a Chapter 11. And again, I'm Eric Lanigan, Lanigan&Lanigan, attorneys in Winter Park, Florida.